Dear guests, thank you for joining us for today's webinar of the Global Reflection Series hosted by Enstitü Sosyal. We are pleased to welcome a very dear friend of mine, Dr. Ahmad Amara, a human rights advocate and legal scholar, and a policy member at Al-Shabaka. Dr. Amara holds a PhD from New York University and has previously worked with Harvard Law School's Human Rights Program. His research and publications mostly focuses on law, history, and indigenous rights in Palestine. Drawing on his background in history, law, and human rights, Dr. Amara will explore how property relations have shaped questions of justice, identity, and rights in Palestine. Please join me in a warmly welcoming for Dr. Ahmad Amara. Ehlen ve sehlen Ustaz. Welcome to the meeting.
Thank you very much. Hoş bulduk.
Hoş geldiniz.
Çok teşekkür ederim.
No, we are very thankful to have you here. And the floor is yours. You might start your presentation.
Thank you very much. Good evening, everyone. Until I upload the presentation, I'm hoping to share with you today two major, let's say, land and legal questions in Palestine, from Palestine. But I want to share two major land questions in Palestine. One is in Jerusalem, of what's happening, and one is in the Negev, or Bir al-Saba', which is southern Palestine. And specifically these two cases because they bear very much relevance to the Ottoman legal history, the Ottoman land law and Ottoman history. My other goal is to show the interactions, again, of the geographical transformations, connecting with questions of sovereignty, of Judaization and colonization in Palestine. Now, this is taking place all over Palestine for the last century, but every time there are different legal and historical and geopolitical questions that arise. I wanted to start with the question, first of all, one of the recent books that I have published to the left is called Diyaru Bir al-Saba'. This is the Bir al-Saba' region, Ottoman Southern Palestine, land, law, and society. Land, state, and society, excuse me. And two other books, in addition to these, still discuss the question of the Negev from legal and historical perspectives. One is very historical, one is very current, about the Israeli legal system. And there is another book that discusses a phenomena of colonizing and Israeli settlements inside Palestinian neighborhoods, which is not like the big Israeli settlements, let's say, around Jerusalem or in the West Bank, but rather very much in the heart of Palestinian neighborhoods. Now, the common of all of this is obviously colonization, but also land disposition and Ottoman law and history. If you allow me to briefly show the broader context before 1948 and after 1948, obviously Israel was established in most of the area of historical Palestine, 78%, and in 1967 occupied the rest. But when in 1948 Israel was created, all the Zionist and Jewish individuals and institutions purchased 6% of Palestine's land. Nowadays, in Israel, we are talking about over 96% of the land is state and public land. And this shift from the 6% in the whole area of Palestine to the 96% is absolutely backed up by legalistic approach and legal frameworks. The methods and the means vary, but obviously it's land confiscation and transfer from Palestinian hands to Jewish and state hands. And I say Jewish and state because most of the lands are state lands. There are some lands that are owned by what's called the Jewish National Fund, which is an institution that was established in 1901. And they started to purchase lands already at the end of the Ottoman period in Palestine, and then during the British Mandate. And after 1948, they were given special status by the state. How did that happen? First of all, land disposition from Palestinians and confiscation to the Israeli state and institutions. And then the idea was the Jewidization of Palestine, meaning building settlements, preventing Palestinians from returning to the land, preventing Palestinian localities from expanding, and also making sure that these lands that were confiscated already, they remain under control for the state objectives. And thus, we can see many state institutions, whether the Israel Land Authority or the Jewish National Fund or the Jewish Agency, World Zionist organizations, settlers organizations, or work within a very complex apparatus of barring Palestinians even from accessing these confiscated lands. And the main legal acts that Israel used to shift from the 6 to the 96% are listed here below. One is already a British law, 1943 Land Ordinance, which basically allows the state to confiscate land for public purposes, but Israel used it to confiscate lands for Jewish settlements. What they call the 1950 absentees property law, but meaning absentees here are Palestinian refugees and Palestinian displaced persons from their homeland. And here we are talking about 85% of the Palestinian population who were expelled from Palestine in 1948. And the list goes with other legal acts. But for the sake of the time, I'll just go a little quicker. Many times and in different phases, Israeli legal and land policies, they go hand in hand with the very, from period to period with different geopolitical logic. Now here I put, of course, also that's not only the Israeli state, but also pre-1948 Zionist institutions with the British mandate. If we look at the map here, in the middle, the colorful one is the 1947 partition plan of Palestine by the UN to Jewish and Arab states, right? So the yellow is supposed to be the Arab state, and the bluish is the Jewish state. Now, if we look to the black and white, this is the map of the lands that were registered by the British under a land title settlement. Taswiya, it's called. So under this land registration process, if you look at the map, you see exactly that most of the lands that were registered by the British before 1948 are the ones that were supposed to go, as in the other map, to the future Jewish state. Now, I want to jump to the question of the Arab-Palestinian Bedouins in what's known today as the Negev or the Naqab, or rather Bir al-Saba' Qaza. And before establishing Bir al-Saba' under the Ottomans in 1901, the Bedouins belonged to the Ghazi, also Qaza. Now in 1948, most again of the Bedouins from this area that we see in southern Palestine, the Negev, almost 50% of Palestinians. So 85% of the Bedouins were expelled, like the rest of the Palestinians. Those who remained, about 13,000, they all were concentrated by the Israeli authorities in this area that appears as the Sayag on the map, which is 6% of the Negev. Now, all the Bedouins were displaced and concentrated in this small area of the Sayag. And since then, their villages grew, and today they're all considered as illegal villages and subject to demolition. The same applies in the West Bank. Also, there are some 45,000 Bedouins and tens of villages suffering the same experience. Now, what is the question there? The thing is, first of all, this is how the villages, what's called the unrecognized villages, look like. And the hope of the state was to further concentrate the Bedouin into 3 townships, into 3 towns. And they started building, and also the second phase of displacement took place in the 70s and the 80s. What happened is that the state managed to forcefully urbanize and concentrate 50% of the Bedouin live today in such houses that you see, and the rest continue to live in similar villages like this. At the heart of the question is Israeli government does not recognize Bedouin ownership to the land that they live on. And that's why all of these houses that we see here are considered illegal. They're subject to demolitions. And the villages do not get any running water or state electricity or any other services. And because of this argument, since the 1970s, Israel asked the Bedouin to file land registration requests. They did file, and if we see, most of the lands are within the concentration area of the Bedouin. Now, the main argument of the state in this part is that these lands are considered mawat land. And they dig very much into Article 6 of the Ottoman Land Code, Al-Tinji Madde of the Arazi Kanun Namisi, the Ottomans. And here, totally the legal argument in courts and the legal doctrine is fully Ottoman in this case. Like, Israel did not use new Israeli enacted laws. So they used this definition. And as we know, under Article 103, if you do ihya to the mawat land, you receive a title to it. Now, the first, we know, colonial phase in Palestine happened with the British. The British in 1921, as you can see, they passed this law, it's called the Mawat Land Ordinance, and changed the Article 103, saying from now on, no one can revive Mawat land without the permit of the government. And anyone who does so will be considered trespasser. And then they said anyone who claims rights in these lands, they have 2 months to come and register their lands. Now, the Israeli government and the Israeli Supreme Court came and said, okay, Mawat land should be 1.5 mile distance from a village or a town, and this village should be a modern one. Bedouin villages or Bedouin encampments are not considered legitimate inhabited area or a village to measure the distance from. And then such village or town should have existed in 1858, and so on and so on. They made a legal doctrine, an interpretation that makes no sense in the legal discussion and legal scholarship. But nevertheless, said, even if you have cultivated and possessed these lands for 200 years, you miss the opportunity to register these lands, their Mawat land, and thus they are state lands. And we're talking about hundreds of cases that the state today is bringing, or the last 20 years is bringing against Bedouin and winning all of them. And because of this legal argument, Bedouin houses and residency are considered illegal. And this is how, when a demolition takes place in a Bedouin village in the Naqab, in Bir al-Saba, this is how it looks like. Sometimes like this, sometimes more, sometimes less, but it turns very much ups and downs. It has been very tough during the last 2 to 3 years under this current fascist government, which is increasing very much the demolitions against the Bedouin. Even more, when these lands are planted and cultivated, the state sometimes, or used to, have either planes with herbicides to kill the plants, accusing the Bedouin of squattering over these lands, or uprooting the olive trees. Now, this is exactly also the reversal of like history and logic, of course, that when you had Mawat land and you planted the trees, you could get a title to the land and make ihya to the landscape, right? To the land. Here, it's totally opposite. On the name of a legal doctrine, legal definition of the land as Mawat, they destroy all the plants and uproot all the trees very much. I'll dedicate just 3 more minutes to the Negev land question, and then move to Jerusalem, and maybe during the Q&As we can discuss this more. Now, in the research in the book, it's very absurd that you see that 70% of Ottoman Palestine's barley came from this area, from Bir al-Saba, Kazakhstan, right? And most of these barley were exported from Gaza to Europe and to the UK for the beer industry. And even the British, in their land survey in 1948, they already concluded in 1947 in a report to the UN saying every Bedouin acre that can be economically sown is already cultivated by its present Bedouin owners. Now, I don't want to get more into the discussion about Bedouin and Fallah and like the cultivators, peasants, Bedouins, or urban, and the confusion, because in this case, most of the Bedouins lived from cultivation, not animals and pastoral land. It could be different in other areas, but in Palestine, in Bir al-Saba, you could see most of the Bedouins are peasants, basically. They lived from cultivating the land. And this is how it looks like even when the Ottoman established Bir al-Saba in 1900, the Ottoman administration, they purchased land from the Bedouin. They bought 2,000 dunams from the Bedouin families and paid for them. And this is how Bir al-Saba looked like in 1900 in the book. And finally, since 1881, if you see the Shura'i Dawlat decision to the left, there's a decision that about the need to register in the Tapo the Bedouin held lands, and there were some registrations by the Ottomans to the Bedouin lands. And it's mostly because, of course, of the taxation and encouragement and to control the land more and for other reasons. But all of this, of course, failed, let's say, or was dismissed by the Israeli legal system, by the Israeli courts. In parallel, there are also Ottoman land or local land contracts by the Bedouin themselves. Okay, so to sum up, in the Bir al-Saba area, despite the cultivation and the heavy thing, there is a very much reliance on Ottoman law and the amendment from the British to completely deny any Bedouin land rights, despite the historical facts of holding the lands for centuries. Now, Jerusalem. Jerusalem also within this broader context of Judaization and disposition of Palestinian And here we see after 1967 a continuation, basically, of this position in Jerusalem, which started in 1948. In 1967, when Israel occupied East Jerusalem, Jerusalem that was like basically 4 square kilometers or 6 square kilometers only. That's the 1967 East Jerusalem. But when Israel occupied it, it expanded the borders of East Jerusalem to become 72 square kilometers. It expanded it 12 times more. And the logic, again, was as much as possible land with as less as possible Palestinians to be annexed to the city. Abdullah Abi, how much time do I have?
We are actually running a bit short on time, so maybe we can skip a few.
Okay. So basically, Jerusalem, the same, started with, I'll take 5 minutes only on Jerusalem. A confiscation right away of 40% of the land in Jerusalem, establishing massive settlements that are called by the Israelis, of course, neighborhoods of Jerusalem, but we're talking nearly about 300,000 Israeli settlers. And these are, if you look also geopolitically, they're around the city to disconnect Jerusalem from the rest of the West Bank and envelop it with Israeli settlements. Right away, if you look here, it's what's called the Western Wall Plaza, Al-Buraq, which started 2 days after the war, right after the war. That's the first destruction in the city and Judaization process, which was the Mughrabi, the Maghribi quarters in the old city, totally bulldozed, and then opening the plaza and building a massive Jewish-only housing project. What the book discusses, and this is a new thing, is that in the last 2 to 3 decades, Israeli settlers organizations rely very much in a legal amendment in the Israeli law that basically, without getting to the legal technicalities of it, allow Jews only to reclaim properties that they owned in East Jerusalem before 1948. Right? If you're Palestinians, you cannot claim any in West Jerusalem or elsewhere or in East Jerusalem. And what happened that Israeli settlers organization, you see in the city inside, all of these flags are houses occupied by Israeli settlers, the blue dots. And one specific example is Silwan, which is in the southern part of the old city of Al-Aqsa, started with Yemenite Jews who immigrated here, and wealthy Jewish leaders in the city decided to build housing units for these Jewish Yemenites and got a permit from the Sultan to build the houses, and then made a waqf in 1900. We are here talking about 1888, 1900, a waqf. This is how the project looked in the early of the century. This is how Silwan looks today, and where are the houses. And again, without getting to the technicalities, a settlers organization went to the Israeli court, appointed themselves as mutavalli of the Jewish waqf, and started suing Palestinians who live in Silwan, in the same lands nowadays, and taking over the houses, if you see, in the middle of the neighborhood with the Israeli flags, exactly based on this Ottoman, basically pluralistic city of Jerusalem, using this together with the Israeli law, a little in the middle with Jordanian history that I don't want to get into it. But what's happening in Silwan, and you see all of this neighborhood is where basically that historical project was, but is threatened by eviction and disposition of hundreds of Palestinians from these neighborhoods. And this is what characterizes specifically this colonial project by settlers organization, relying on Ottoman history and heritage of Ottoman Jerusalem and bringing the cases today to the court. This is happening in Silwan, this is happening in the Old City, this is happening in Sheikh Jarrah, in Beit Hanina, and in other towns in Jerusalem. And I think I'll stop here and to leave time for Q&A. Thank you.
Thank you so much, Dr. Amara, for this wonderful presentation that you let us focus on different parts of Palestine, like Bir Seba or Silwan or any other places. If you allow me, I would like to go back to one of the archival documents that request some land from the Ottomans, right? If I'm not mistaken.
Yes.
Again, if I'm not mistaken, from the book of Julia Phillips Cohen, Becoming Ottomans, I remember that these kind of petitions were given to the Baba Ali, to the Ottoman governance, but they were mostly refused.
Mm-hmm. Yes.
So is there something special about this request, or it was just the time being, from time to time, they let them to obtain some lands, and there comes a time they put a stop to this?
Are you talking about specifically in Silwan or in other?
No, in general, Jewish settlers requesting lands in different places.
Yes, yes. Look, obviously, in the scholarship about Palestine, specifically about land, we usually talk about the dual colonial project in Palestine, which is the British and the Zionist that was taking place. And it's important to note that what the Zionist institutions and the Jews purchased before 1948, which tantamount to 6%, was mostly the large sales were by non-Palestinians. They were by Syrian or Lebanese landlord. Am I in mute? No. Landlord families. Or by the Greek Orthodox Patriarchate, which the British sold to the Jews. But one episode is usually missed because we focus on the British, that 1/3 of this land, which is 2% of Palestine, was purchased also in the late Ottoman period. Okay? I mean, we can't get very much into the details how this happened, but we're talking about nearly 40 Zionist, let's say, colonies that were established during the late Ottoman period in Palestine. And we're talking about nearly 600,000 dunams, which is like 30% to 35% of what was purchased before 1948 was under the Ottoman rule. Now, there were legal amendments to prevent these sales and building. There was a lot of pressure by European consulates and powers. There were just economic land sales. There were ways how to bypass these restrictions by Ottoman Jews basically buying for European Jews. And so there were different ways. But that, took place. We're talking about considerably like big or large amount, about 1/3 of the lands happened or took place under the Ottoman rule.
Okay, I have another question, but do you mind closing the sharing of the presentation before we continue?
Yes, sure.
Thank you so much. You have shown us lots of documents. And if we want to negotiate using laws or legal techniques, what should be done first? I mean, what is the most useful tool of negotiating to reclaim this kind of lands?
The two examples I gave, I think they present two different strategies of negotiation. First of all, we are talking about legal or legalistic apparatus that is very violent and very biased. And I mean, I don't want to get just really to the biasness and the nonsense of the law, but it's a logic of violence and colonization, that's for sure. In the Negev, in Bir Seba, people's presence on the land, despite pressure, despite demolition, despite lack of services and suffering hardship. That's the main tool of negotiation. The legal cases, they're not doing any difference. And there was, let's speak legally speaking, there was a shift from focusing in courts on land rights, which totally failed, to focusing on civil and political rights. Basically saying, for example, you need education for the kids, you need health clinic, etc., but not to come and argue that these people are here before any Zionist immigrant and settler came to Palestine 100 years ago. And they own the land, they cultivate it, they export it, they registered, they paid taxes. All of this didn't help. What happens in Jerusalem is a little different. It's also more a strategy of buying time and not getting really acknowledgement. It's very few cases that you can win. Again, like, what do you need more than a law that a Palestinian who lives in such a house in Silwan, his house is in Western Jerusalem, let's say in Talbiya neighborhood. It's like a 3 stories mansion that is confiscated, and you have even a Supreme Court son or judge himself or his son living in this house that was confiscated in 1948. And he's saying, like, I'm displaced once and twice and 3 times, and now you're displacing me from here, but my house is there. But again, the law works only one way in Jerusalem in this case. So here it's really a hope, like, to buy time and push against the odds and not to win the cases or change the time. So in Sheikh Jarrah, when the legal battle in Sheikh Jarrah, for example, maybe some of our audience know more about Sheikh Jarrah because of what happened in 2021 with the major demonstrations in the Sheikh Jarrah neighborhood. The legal case in Sheikh Jarrah has been ongoing since 1974 until today. We're talking about nearly 50 years of legal battle, but only when the youth took to the streets and you had mass protests, things started to change a little bit about Sheikh Jarrah. So the strategy or the negotiation is about time or about presence, just until a political thing changes, or about protest and popular movement on the street.
Okay, thank you, Dr. Ahmad Amara. There is one question from the audience. Yusuf Bey is asking, from your standpoint as a lawyer, how did negotiation function as a legal tool within Ottoman land law, particularly in mediating between state authority, local actors, and competing claims to land in Palestine?
So, look, there is more and more interest in the Ottoman land law and history recently. And I myself, in my research and in my work as a lawyer, see very much the Ottoman history and land law, the legal system, is very much important area of negotiating between the different claims. Many times, especially in the Bir al-Saba, it failed. The Ottoman. In Jerusalem, there were a few successes with it. On the other hand, in Bir al-Saba, it did contribute very much, not to the court, but really to the history and the morals of the area. It's an area that deemed as a desert with Bedouin who are pastoral and nomadic, and it's like an arid area. But when people learn more about the cultivation and the history and the registration and the purchases and land books, and we're still discovering more and more, it did play very much in this perception, like in this perspective also about Palestine in general and Southern Palestine in particular, and especially among the local Bedouin communities in Southern Palestine. So it's present, it's increasing, and it played differently from the court to the people themselves, to the society, to the lawyers.
Okay, maybe I can add a follow-up question to that if there is a direct or indirect relation between the Ottoman legal codes, land registrations, legalization, and the Palestine problem. If the problem actually occurs that comes from the legal codes or land registration system of the Ottomans, or something that broke away in the way?
No, it comes from many things that broke away on the way. I mean, you could see very much actually from the first 2 months with the British occupation, how the British made few amendments to the Ottoman land law, but basically to facilitate the colonization of lands by the Zionists. That doesn't to say, of course, that the law, the Ottoman legal system was perfect. The problem is today that many, whether scholars or courts, try to project very much and read the Ottoman land system and registration in today's lenses, like in a modern lens. So if there is a land registration, which was very valid, or land rights that were also valid without land registration, even with local documents, today simply the court tells you where are the borders of the lands. Even if you show it's the same land, you paid taxes, you have Ottoman registration documents, etc. So the thing is, we did not have many, I think less than 10% of Palestine's land was registered under the Ottoman Tapu New system. You still have many that were in the Sharia code. Right, in local books with the local leaders and Mukhtars. So it's very messy system. But when the British even, quote unquote, modernized, they came with the new land registration system, which is based on the torrents, talking about a parcel, a block, and surveyed mapping with coordinates, exact coordinates. They did this only in the intended future Jewish state areas. So they left also 80% of Palestine unregistered, but still the British system of registration was much more, let's say, liberal or logical in the way of registering Palestinian land rights, unlike the Israeli legal system. Israeli land registration system denies 90% of Palestinians land claims. And in the case of the Negev, even 100% of the land claims. So there is, the evolution, the transformation of the legal system itself, the registration of title, how it happened, and of course, the ideological, political ideology behind the registration of these lands.
Okay, I have one last and general question for you, Dr. Amara, and I think it's important to put a point to this. Are there any important misconceptions about Ottoman Palestine, or let's say the Palestinian problem, in popular or academic discourse that you would like to correct?
I mean, mostly what is happening is misconceptions from here, is reading, again, 400 years of Ottoman rule in Palestine through nationalistic approach, talking about, ignorance or primitivism, primitive culture in Palestine. I think that's the most that is happening. But really, from the areas that are interesting to focus on from my research is Jerusalem, mid-19th century transformation that is continuing very much with us today in the present. Jerusalem very much changed after let's say, the Egyptian by Mehmet Ali Pasha and Ibrahim Pasha from the 1840s, let's say, onwards. Jerusalem changed very much because of the capitulation agreements. So most of the old city and what's happening around it is the outcome of that period. The exemption of the Ottoman period with Zionist colonization and Zionist land purchase, and also really the details that were taking place, the bureaucracy, the building, the planning that was taking place in southern Palestine, especially at the beginning of the 20th century, is very, very strong and very detailed and still very present until the day. So I think very much is from like the continuities more than the discontinuities that taken place from the Ottoman to the British to the Israeli, of course, in Palestine. But we rather focus very much on these ruptures or ignore many of this heritage that is taking place until the present.
So we extend our sincere thanks to Dr. Ahmad Amara for his wonderful and thought-provoking contribution and his presentation. His analysis offered a powerful perspective on law, history, and human rights of the Palestine in general. We also would like to thank all our participants for joining us and look forward to continuing this dialogue in future Institute social events. Thank you all for coming. Hem hepinize geldiğiniz için teşekkür ederiz. Bir sonraki programımızda tekrar görüşmeyi ümit ediyoruz. Hayırlı akşamlarınız olsun.
İyi akşamlar. Çok teşekkür ederim abi.
Biz teşekkür ederiz.
Görüşürüz.